Welcome to this complete masterclass explainer on the legal principles of towage and pilotage. Whether you're coming to this with absolutely zero background in maritime law, or you're just looking to really solidify your foundation, you are in the right place. I'm going to be guiding you through every concept, every case, and every rule you need to completely master this topic step by step. Let's get started.
Towage and pilotage are essential maritime services that dictate exactly who holds the ultimate legal liability when massive vessels maneuver through ports or face crises at sea. Okay, let's dive right into this. On our agenda for today, first, an introduction to towage services. Then, we'll look at towage categories and contracts. Third, we'll cover the crucial difference between towage versus salvage. After that, we'll get into the principles of pilotage. And finally, we'll wrap up with a comprehensive legal recap. Moving right along to Section 1, Introduction to Towage Services, Moving the Giants. Before we look at the strict legal definition, let's just use a really simple, plain language analogy. I want you to think of towage kind of like hiring a heavy-duty tow truck for a broken-down car, but with one major twist. You are still sitting right there in the driver's seat, actually steering the car while it gets pulled. It's a paid, prearranged service for moving your vehicle. It is absolutely not an emergency rescue. Okay, now let's lock in the precise legal definition. You might want to take a moment to note this down. Towage is a service contract where one vessel, which is known as the tug, assists in moving or maneuvering another, known as the tow, that either cannot move under its own power or just simply chooses not to. So this could mean entering or leaving a port, maneuvering in really confined waters, or even moving a disabled ship, a barge, or a massive oil rig across long distances. So the really crucial point here is the legal nature of this service and why it actually matters. Towage is just a straightforward contract for reward. Critically, the tug does not take legal possession or control of the tow. The towed vessel, assuming it's manned, generally stays under its own master's command, unless the contract explicitly says otherwise. And in maritime law, this exact question, who is actually in command, well, that is exactly what drives the vast majority of liability disputes. Let's move over to Section 2. Towage categories and contracts, harbor versus ocean. We're going to see how this all builds into real-world commercial agreements. Towage basically falls into two main categories. First up, we have harbor or river towage. This is short-distance maneuvering to assist with berthing a ship. Keep in mind, this is very often compulsory under local port regulations for larger vessels. Second, we have ocean or deep-sea towage. Now, this involves the long voyage moving of a disabled ship, or relocating massive structures like oil rigs across the open water. Because these two services are so distinct, they naturally use different standard forms of contract. For harbor towage, the UK Standard Towage Conditions, or UKSTC, is historically the dominant form. And wow, it is notoriously tug owner friendly. It often exempts the tug almost entirely from liability, and get this, it even requires the tow owner to indemnify the tug for the tug's own negligence. Now, I know that sounds incredibly lopsided, but you have to consider the commercial reality here. Harbor towage is frequently compulsory, and tug operators simply wouldn't offer the service without that sweeping protection. Now, for ocean towage, the industry often uses BIMCO forms. There's TowCon for a lump sum payment and TowHire for a daily hire rate. Finally, a lot of towage contracts rely on what's called knock-for-knock liability allocation. This simply means each party bears its own losses, completely regardless of fault. This is a distinctly maritime departure from ordinary negligence-based liability, and definitely a key concept you'll want to remember. Moving on to Section 3, towage versus salvage, when contracts become rescues. Honestly, this is arguably the most frequently tested distinction in all of maritime law. Now, what's really interesting here is how we separate a standard business transaction from a genuine emergency. Let's walk through the differences. First, look at the trigger. Towage is purely contractual and prearranged. Salvage, on the other hand, requires a vessel to be in actual marine peril. Next, let's look at payment. Towage is a fixed amount that's owed regardless of the outcome. Salvage operates on the famous, age-old principle of no cure, no pay. And for the basis of reward, towage pays a previously agreed rate. Salvage rewards are based on the value of the property saved, the skill involved, the risk taken by the salvers, and the time spent. So this naturally brings us to a pretty complex scenario. What happens if things go wrong? When does a standard towage service legally convert into a salvage operation right in the middle of the job? To answer that, we have to look at the landmark 1928 case, the Homewood. The facts here are pretty straightforward. A standard towage operation was underway when it suddenly faced an unexpected severe marine peril mid-operation. So the central legal issue became a massive point of contention. Can a tug claim a highly lucrative salvage reward for rescuing a vessel it was already legally contracted to tow for a fixed fee? Well, the court provided a very strict two-part test for this. The holding in the Homewood states that conversion to salvage requires both a genuine peril not contemplated by the original towage agreement and services genuinely going beyond what the towage contract actually covers. If the tug is just working a bit harder because of some bad weather, well, that's not enough. Absolutely both elements of this test must be satisfied to trigger a salvage claim. All right, let's transition over to the second major topic of this explainer, in Section 4. Principles of Pilotage, Navigating the Unknown. Again, let's start with a plain language analogy to get our bearings. Pilotage is sort of like having a highly specialized local guide sit right in your passenger seat to help you navigate a hazardous, unfamiliar shortcut, but you keep your hands firmly on the steering wheel. A licensed pilot brings specialized local knowledge, things like currents, hidden depths, tricky traffic patterns, and local regulations, boarding your vessels specifically to advise you through harbors, channels, and rivers. Now, let's override that analogy with the precise legal rule. Even with the pilot aboard, directing the navigation, the master remains in overall command of the vessel. Pilotage is strictly advisory. It is not a transfer of command. Because of this, the ship owner generally remains fully liable for the vessel's navigation, even when a disastrous error was directly caused by the pilot and not the crew. You see, many ports actually mandate pilotage for vessels over a certain size. For example, in India, compulsory pilotage is mandated through the Indian Ports Act of 1908, right alongside specific bylaws issued under the Major Port Authorities Act of 2021, which recently replaced the older 1963 Act. Now, historically, some jurisdictions actually gave ship owners a defense if the pilotage was compulsory. The logic made sense, right? I had no choice in accepting this pilot, so I shouldn't be liable for their mistakes. But that defense has narrowed sharply over the years. The modern position, which is reinforced by P&I club insurance practice, is that the owner remains completely liable regardless of whether the pilotage was compulsory or voluntary. The law basically views the vessel itself as the instrument causing the harm. And this next scenario brilliantly illustrates the rule in practice. Just imagine a massive container ship approaching Jawaharlal Nehru Port, or JNPT. It takes on a compulsory harbor pilot for that final tricky channel approach. If that ship runs aground entirely due to the pilot's navigational error, the ship owner still bears the liability to third parties. If there's pollution or if wreck removal is needed, the ship owner is the one who pays, totally regardless of the pilot's fault. Now, the owner might have separate contractual or insurance ways to seek recourse against the pilotage authority later on, but that frontline liability, it stays right there with the ship. We have thoroughly unpacked these vital doctrines today. Let's move to Section 5, our comprehensive legal recap, to really cement everything you've learned. If you're taking notes, this is definitely the moment to pause. First, we defined towage as a contracted maneuvering service, where the ship's master keeps command. Then, we looked at the specific forms. UKSTC, which is highly tug-friendly for those compulsory harbor scenarios, along with towcon and tow hire for ocean voyages. We defined knock-for-knock liability, meaning each party bears its own losses. And we contrasted towage versus salvage, highlighting that key difference between a prearranged contract with fixed pay versus an actual marine peril operating on no cure, no pay. Continuing our recap, we studied the 1928 case, the Homewood, which established that conversion to salvage strictly requires an uncontemplated peril, plus genuine extra services outside the contract. We then defined pilotage as advisory local navigation, where the master absolutely retains command. And finally, we covered the modern liability rule. The ship owner is strictly liable for a pilot's navigational errors, even if that pilotage was mandated by law, just like in our JNPT compulsory pilotage illustration. I really want to thank you for your focus today, but before we go, I'll leave you with this final, provocative question to think about. If the ship owner is held strictly liable for a mandatory pilot's catastrophic error, someone they were literally forced by law to bring aboard, does maritime law fundamentally prioritize swiftly compensating victims and protecting ports over establishing true direct fault? It is an incredibly heavy philosophical question right at the heart of commercial shipping. Think on it, and I'll see you in the next explainer.